Hope you are doing well. So today's topics include talk about Article 293 and 292 of the Constitution. Why this matter is in the news because of the Supreme Court has referred to Constitution bench which Kerala filed a suit against centre's shackles on the state's borrowing powers. The matter relates to Article 292 and 293. I would be talking about it. Second topic actually talks about solar industry of India. Yesterday we talked about the nuclear industry. Today we would be doing something about the solar industry. Third is the prevention of money laundering law. So prevention of money laundering law, why it was implemented, what is history been, and how it is being dealt with. Number fourth includes artificial intelligence and its roles in elections, the positive and the negative. Whenever you are writing about the new technologies or artificial intelligence, you can remember this dimension. Number five is about the Katchatheevu Island issue that is between India and Sri Lanka and how the politics is being played on or how the debate is being carried out in India as of now. So we talk about the first one. Supreme Court refers Kerala government's suit on the net borrowing cap to 5-judge bench. When we talk about Article 292, because 292 of our Constitution deals with the borrowings. So the executive power of the Union then extends to the borrowing upon the security of the Consolidated Fund of India within such limits if as may time be fixed by Parliament. So why so? Because of Government of India needs money to run its businesses. Not only Government of India but even the states also needs borrowing etc. So they can plug their own finances plus whatever the socio-economic or other industrial investments that they have to make, they do it through borrowings. So Article 293 actually talks about the executive power of the Union that actually on Consolidated Fund of India, you can keep the Consolidated Fund of India as a security and within such limits from time to time as fixed by Parliament and giving by guarantees, these borrowings can be done. So under Article 268, when it was debated on 10th of August 1949, the draft article provided that Union could borrow funds and can give guarantee against the revenues of India within the limits fixed by law. So this is Article 293. When we talk about Article 292, when we talk about Article 293 of the Constitution, so that actually deals about the borrowing by states. So Article 292 actually talks about borrowing by the Union and it talked about Article 293 about borrowing by the states. So subject to the provision, the executive power of a state extends to the borrowing within the territory of India upon the security of the Consolidated Fund of that state within such limits as the legislature of that state actually can give them the guarantee. Government of India may subject to such conditions as may laid down under Article 293 and that is not exceeded. So Article 292 and 293 talks about the borrowing. Those happens through the security provided by Consolidated Fund of India or Consolidated Fund of States. So why there is a sudden news over it? So Kerala government actually filed a suit in the in the Supreme Court. And Supreme Court has said that center has given Kerala substantial relief of over 13,000 crore rupees to tide over the immediate financial crisis. Kerala government says that we cannot borrow more because center has a regulation and center's regulation do not allow us to borrow again even exceeding the borrowing limits. And they say that we are having a deep financial stress and if we don't borrow, our financial situation can even reach in a dire state. So the Supreme Court on Monday referred to the Constitution bench the question raised by Kerala whether state has an enforceable rights to raise its borrowing limits. You must know that Article 293 and 292 of the Constitution talks about limits. Those are set by respective state legislature and respective union legislature. So when the union actually has placed a limit, and you must also know that when we talk about fiscal federalism, the power of the union far greater exceeds than the union states powers. So that's why the court wants a 5-judge bench to decide important questions of the law regarding fiscal decentralization. So whether fiscal decentralization was ever a topic that was discussed during the Constitution Assembly or if it was part of an aspect of the Indian federalism. we must know that there is a democratic decentralization, a process by which, we have given a constitutional status to even the local body institutions like Panchayati Raj and union territory, urban local bodies. Similar way, they talk about the financial or fiscal decentralization. Can that happen in the sphere of finances or the financial relations between state and the union? So court raised this issue. The financial restrictions introduced by the center had meted out a different treatment to Kerala compared to other states. So the two judge bench actually has decided about it, and the constitution bench will be then hearing about it. If the state has essentially created financial hardship because of its own, now what is the contention? So number one contention is this: a state, number one, a state actually for its own financial mess cannot held center always, necessary or responsible, that center has to take care whatever the financial mess that the state is in. So this actually problem does not lies at the door of the union. Bench observed that center had already allowed a substantial relief of over 13,000 crore rupees. The court also noted that balance of convenience lay in favor of the center because it has already given the additional amount. Although the court highlighted that center's conduct during the hearing of the case, when it actually pressed the state of Kerala to withdraw its suit in the return of financial help, was not necessary. Division bench noted that there was a vacuum in law concerning Article 293 of the Constitution, which dealt with the financial borrowings by states. Kerala had approached the apex court arguing that center's shackles on the state's borrowing powers was an attack on the federalism. So you can be asked questions in multiple ways. Number one, role of Article 292 and 293 in ensuring fiscal federalism in our country. It can also be argued in the GS questions that, the kind of limits that the union sets for the states to borrow, is it according to the fiscal federalism or not? Or whenever we talk about the cooperative federalism or competitive federalism, you can always write down about the dimensions. But you should also note that whichever state, because there are around most of the states which remain under the financial or financial, limits. And if they are under financial limits, then the center actually takes care of their finances. But when the finances are or spent actually without any kind of, regard to the limits, borrowing, etc., then the center also has to place a limit, because that the fiscal deficit of our governments is under FRBM Act. There is a law that talks about fiscal deficit to be under control. Although during Corona, it went out of control because the government finances or revenues slipped and government's expenditures either remained the same or risen. That's why it is important part of the fiscal federalism. But the court will be deciding whether fiscal decentralization was ever a part of fiscal federalism setup that was negotiated when we were writing the constitution. And that's why this news is an important piece of news. Now we come to the second thing, and that is India's solar surge. As you must know that solar industry is definitely going to play a major role in not only ensuring that India actually receives a clean energy, but also for the climate goals of India, whether these are part of the Paris or recently concluded UAE summit of COP28. So India actually has a greater, whenever we talk about the solar industry or renewable energy capacity, our goal is to score close to 50% of the power through renewable energy sources. And yesterday we talked about how the nuclear energy is going to help India. Nuclear energy that is supposed to be creating close to 7.5 gigawatt in the country as of now. The capacity will be tripled, and it will go up to 23 gigawatt by 2031 2032. Similarly, solar energy, if we talk about, then India actually desires to generate close to 100 gigawatt from solar energy. So these solar energy or nuclear energy or wind energy will definitely be a milestone for India to achieve that 50% renewable energy power needs for our country. So the new financial year has begun with the government finally bringing into effect a policy that will discourage solar power project developers from relying on imported panels. So the question is about the imported panels. Those panels which are imported, there has always been a talk about even quality also and increasing reliance on countries like China. That's why India is also trying to make that, the manufacturing of these solar panels should happen in our country itself. The approved models and manufacturers of solar photovoltaic modules order 2019 requires modules makers to submit an inspection of their manufacturing facilities by the National Institute of Solar Energy. So being in the list of as approved manufacturing facility certifies a company as legitimately manufacturing solar power. This includes the recently announced PM solar rooftop scheme as well. So the major advantage is eligibility to compete with the government tenders. So first of all, what we are trying to do, we are trying to set up manufacturing base in our country itself. So that's why the reliance on other countries can be reduced. Even the quality and the product specifications that we require can be met as a standard project specification here in our country itself. So the creation of such these kind of approved models manufacturing lists was also aimed at restricting imports from China, which controls nearly 80% of global supply chains. India, that has a ambitious plans of sourcing about 500 gigawatt, nearly half of its requirement of electricity from the non-renewable energy sources by 2030. This would mean that at least 280 gigawatt should come from solar itself, or at least 40 gigawatt of solar capacity being annually added. As you know, we are in 2024. We have achieved the 100 gigawatt phenomena in solar energy generation. But if we are to meet 280 gigawatt through solar energy by 2030, then we require to add close to 40 gigawatt of solar power a year up to 2030. In the last 5 years, this has barely crossed 13 gigawatt because of the corona issues and other problems. So to reach 40 gigawatt, we require fast tracking of not only approvals but also a supply chain that is more robust enough, so the solar panels etc. those are prepared are of better quality. So the yardstick of success is when India meets its 2030 commitment while ensuring that solar power is affordable to most Indians. This means that the domestic manufacturer should be subject to stringent quality checks and should not allow on cost and quality measures on other issues. So the contention is this, that solar industry is definitely need of the hour. Solar power is definitely need of the hour, and we need to also cut reliance on China, because as our solar industry increases, the growth in scale would be inevitable even for countries actually which are either supplying us the material, or even if we start manufacturing in our industry in our country itself. So the scale will happen, but when the scale happens, we require the quality control to continue, because solar industry cannot remain cannot breathe and sit silent, because each and every year we have to include close to 40 gigawatts into the solar power kitty, so that by 2030 we reach the goals of 280 gigawatt that is generated by solar and solar itself. We now come to the third topic, that is prevention of money laundering law. Prevention of money laundering is basically a notable effect to fight the money laundering charges. So why this law was included? So prevention of money laundering that was implemented in 2002 was enacted with a distinct objective. Number one, because of the volumes of the black money that were generated through international drug trafficking posed a grave threat to the economies of many countries. So what was the history? History was that all those countries whose economies were getting grave threat, so they wanted to control the international drug trafficking etc. that can harm the economies. There was widespread realization that the black money generated through the flourishing drug trade and integrated into the legitimate economy was likely to destabilize the world economy itself. So the United Nations, took a greater note of it, and in 1988, the United Nations Convention Against Illicit Traffic in Narcotic Drugs and Psychotropic Substances was brought in. All countries were urged to take steps to prevent laundering of the proceeds of the drug crimes and other connected activities. You must know that what is laundering. Laundering means when something dirt money, that is black money, is transferred by certain layering mechanisms and it is transferred into a clean money. So here white money. So that is called the laundering. Subsequent to this, 7 major industrial nations held a meeting in Paris and established the Financial Action Task Force. So whenever either you are also talked about, what is Financial Action Task Force, you can say that after in 1988, the United Nations actually, Convention Against Illicit Traffic in Drugs, Narcotic Drugs and Psychotropic Substances was was implemented. Seven major industrial nations held a meeting in Paris and decided to establish the Financial Action Task Force to examine the problem of money laundering and recommended measures to tackle this menace. So in 1990, the resolution, namely called Political Declaration and Global Program of Action, was called upon by other member countries and enacted a suitable piece of legislation to effectively prevent the money laundering. So that is how we have, or countries actually have come to uh, implement the FATF, that is Financial Action Task Force. In pursuance of this resolution of the United Nations General Assembly, the government of India used the recommendation of the FATF to formulate a legislation to prevent drug money laundering. As drug trafficking is a transporter operation, the United Nations held a special session on the theme Countering World Drug Problem Together. So, Indian Parliament enacted the Prevention of Money Laundering Act in 2002, but it was brought into the force in 2005. This narration of history of this law is necessary because you need to understand, what were the circumstances through which the Prevention of Money Laundering Act was implemented, how the FATF also came into picture, and how the United Nations Convention Against the Illicit and Other Drug Problem also arose. So the law on money laundering revolves around crime proceeds which are laundered. Not only the persons involved directly in the crime and the generation of crime proceeds, but also the persons who have nothing to do with the crime but who have some involvement at a later stage in the laundering process are also guilty under this law. That's why the PMLA is a wholesome law that not only actually talks about the crime proceeds, but even those persons who are either not involved or either involved directly but even has helped in the later stages of laundering processes are also made guilty. The other aspect of the PMLA is that includes a large number of offenses in the schedule which have nothing to do with the original purpose of this law, like combating the laundering of drug money. The United Nations resolution on the basis of which the law on laundering was enacted in India spoke about only the offense of laundering of the drug money. This was considered the most serious of economic crime which had the potential to destabilize the world economy itself. That's why PMLA was enacted by India's parliament under Article 253, which empowers the union to implement or make laws for implementing the international conventions. A law Parliament makes to implement any decision of an international body will be confined to the subject matters of that decision itself. So Article 13 in the Union list of the 7th schedule of the Constitution is specific on this particular point. Thus, the law on money laundering enacted under Article 253 and Item 13 of the Union list in the context of UN resolution. So this is the money laundering law that India implemented. And what were the circumstances that were what actually circumstances that led to us doing this PMLA Act? So what does the Act do? Act enables the government authorities to confiscate. So what the government authorities do? They confiscate the proceeds actually by the proceeds or property or money that has been earned through illegal sources or through money laundering. So PMLA Act is what? Number one, it enables the government authorities to confiscate properties or assets earned from illegal sources and through money laundering. Under the PMLA Act, the burden of proof lies with the accused, who has to prove that the suspect property or assets have not been obtained from proceeds of the crime. So the objectives are: number one, to prevent money laundering; number two, combating the channels of money into illegal activities; number third, providing for confiscation of the properties; number four, providing for any other matters connected with an act of money laundering. So these are this is the PMLA or the law. So offenses under PMLA include offenses like Indian Penal Code, Prevention of Corruption Act, Narcotic Drugs, Psychotropic Substances, Antiquities and Arts Treasures Act, Trademark Act, Wildlife Protection Act, Copyright Act, and Information Technology Act. Even actually those offenses which are value of more than 1 crore rupees, they are also mentioned under PMLA. Part C of the PMLA also includes trans-border crimes. So this is the PMLA and how we are doing, or what is the manner in which we are doing this. AI in elections, the good, the bad, and the ugly. As you know, artificial intelligence. So, this is an intelligence. When we talk about the artificial intelligence, you must know that this is the capacity of the machines by which they start to think just like they are the intelligence those have been shown by humans. So they try to mimic humans to show that is how they behave and what kind of decisions they take, just mirror like they are using the intelligence just like as a human. So it's a simulation of human intelligence processed by machines, especially the computer system, etc. So whenever we talk about the artificial intelligence, we require the computing powers on a much larger scale. So the computing power those are required are helped by not only the governments but all those investors, those actually spend a lot of good amount of money. So that's why these kind of computing channels can be, or computing programmings etc can be laid infrastructurally. So in an effort to broaden, so why AI in election is now being talked about here. Prime Minister of our country recently used this AI in his election speeches. And what was the point? To just telecast his speech that was delivered in one language into multiple languages, where the target audience did not necessarily understand the language in which he spoke. So the AI is being used as a language converter, or even directly interacting with their consumer, with their those people who are coming to attend the rallies. So the widest application of AI with its seemingly limitless possibilities is likely to bring about a paradigm shift in the general election in 2024. Earlier, there was a social media and how it was used actually to convey their messages, either through WhatsApp or either through Facebook and everything. Now, AI has opened a new door altogether, in which not only the language real-time translation, although there are other channels also which are helping the politicians to meet their people, or the demands of those people actually can be directly put for consideration to these politicians. So, but what is the dangers? So the global election of 2024 are in contrast the AI elections. So all those global elections, whether in the USA or in India or elsewhere also, are being talked about, they being the first AI elections. In January, New Hampshire voter answered a phone call from what sounded like a US President Joe Biden. Indeed, it was a robocall made by artificial intelligence. And what was the aim? Aim was to dissuade democratic voters not to turn up to polling station on election day. So this is the danger actually that with which we have to also deal with when we are talking about AI. So you see, without even President Joe Biden's knowing, this particular call that was made by a robot, it made a call using the AI and to those voters. And what it did do? That don't vote for Democratic party. So a Biden actually who belongs to that particular party, can you imagine he will himself say that don't vote for that party, don't vote for that party. So that is a one of the bad effect of AI. In Slovakia, 2 days before the parliamentary elections in September 2023, a recording of a conversation between a journalist and the leader of pro-North Atlantic Treaty Organization, Progressive Slovakia Party, was shared on Facebook, purportedly discussing methods of election manipulation. They both immediately called out the audio as fake, and fact-checking turned up the proof of AI manipulation. So how the actually AI manipulation also happened, and how AI manipulated the conversation between a journalist and a Slovakian political party representative. So that was also one of the negative effect that we see when we are talking about artificial intelligence. Why I'm telling you these things? Because you in answers can mention these things. So in Argentina's turn in October-November 2023, following which an article in the New York Times perceived that with its expanding power and falling cost, artificial intelligence is now likely to be a factor in many democratic elections around the globe. And the main problem is of deep fakes. So deep fakes were used in recent assembly elections in Madhya Pradesh and Telangana. So you know what is deep fake? So deep fake is a technology that is basically dependent on dependent on artificial intelligence, and that have digitally manipulate to replace one person's likely conveniently with that of the another. So suppose say one person's identity or photos etc will be replaced by another person, and the tone and tenor etc will remain like he is the same person or original person is speaking. So in Madhya Pradesh and Telangana, this deep fake was used either through doctored clips of the game show like Kaun Banega Crorepati or a fake video of a leader already pushing voters to support their opponents. So these are the negative effect of AI, particularly in elections. And you know that elections are the cornerstone of a democratically elected country. So elections are all the more important. That's why AI powered bots etc cannot flood the social media site, and we need to take care of. So the regulation is right now just waking up from these kind of things. There is an AI model law that is being prepared in by European Union as well. So these kind of things actually till the time they don't come, it will create a major problem for AI related regulatory arbitrage. So AI is raising the bar for political campaigns with a data driven and effective micro targeting strategy. United States government has outlawed now after that robocall that was made. United States has definitely outlawed this particular AI generated voice assistants. Technology behemoths including Microsoft, Google, OpenAI, and Meta have also talked about combating AI content that aims to deceive voters. So earlier, when we were talking in 2019 about the Facebook role in the Indian elections, now already the concerns about artificial intelligence are emerging in the elections of United States. There has been an example in the Slovakia how that generally stand Slovakia's political parties representative talked about, plus Argentina how the deep fakes were used in Indian election. You must have also heard about prime minister's own deep fakes emerging. So this is particularly a general concern. That's why artificial intelligence defective or effects should be also controlled by the regulator, not only by the government side but even people who are using them use with caution, because it can endanger not only your political system, it can also endanger the security and integrity of your country, because what kind of messaging is being passed by using the deep fake technologies can be seriously dangerous, not only in spreading the communal angle also but about other problems also. When we talk about the final topic, this topic is Katchatheevu Island issue. Katchatheevu, when we talk about, you see, this is the location. This whole is Sri Lanka, and that is our India's coast. So in between, lies this Katchatheevu Island. So this is, first of all, you should understand that this is an uninhabited island, barren island. But this island is now being controlled by and part of the Sri Lanka's sovereignty. Though the Indian government though the Indian government actually never talked about it after 1974, even in earlier records also show that there was a dispute on this particular Katchatheevu, because when we talk about the kings that time and even the Sri Lankan records, how the Portuguese also showed their presence. So this was a dispute point. But in 1974, the then Prime Minister of India and the President of Sri Lanka at the time actually they got together and they accepted Katchatheevan as Sri Lankan area under the Indo-Sri Lankan Maritime Agreement. So this Katchatheevu Island has this. Now, what is the history? So the 1974 agreement has been responsible for improvement in relations between both these countries, India and Sri Lanka, no doubt about it. Under the agreement, Sri Lanka, Katchatheevu Island was found to lie in the Sri Lankan side or Sri Lankan water. So Katchatheevu will be controlled by. So you can be asked a question about the 1974 agreement about Katchatheevu Island, how the dispute about it or debate about it will further harm the Indian interest, or what it will do, or why there is a contention. So 1974, Sri Lanka was given the rights for Katchatheevu. Katchatheevu was found to lie in the Sri Lankan waters, although Indian fishermen retain the right to visit. But for Indian fishermen, because they also had some history with this particular island, so their right to visit to celebrate Saint Anthony's Day was retained at the church or otherwise deserted island, and also allowed to dry the dry nets. Although fishermen can go there and dry their fish nets, but they are not allowed to fish nearby this particular area. And that's why in the last 20 years, according to Ministry of External Affairs, close to 6,000 people have been detained. People of Indian origin have been detained doing the fishing those sides. Close to 1170 vessels or boats also have been detained by Sri Lanka. And that's why this is now becoming a major topic of contention, because this Katchatheevu Island, either by knowing or unknowingly, the fishermen cross it and they fish in those particular waters. So that's why the Katchatheevu Island is now coming into picture once again. The present day government and the opposition are now indulged in the debate about it, and they are saying that Katchatheevu Island was, even the ruling party is saying that the Katchatheevu Island issue was and has been a reason behind Indian fishermen's continuous trouble with the Sri Lankan authorities. Opposition parties say, on the other hand, that if you raise the Katchatheevu issue once again, then it can harm the India's relations with Sri Lanka, or the friendly relation that emerged after 1974. It can even harm them. And in this list, there are ex-diplomats also. Those are cautioning the government on Katchatheevu Island. They say that if you open this particular issue, then it will create a kind of Pandora's box, in which even 2015, when India and Bangladesh signed a land boundary agreement, and by which, although it basically happened on the Permanent Court of Arbitration that ruled in favor of Bangladesh, and India accepted that particular Permanent Court of Arbitration ruling. But when we talk about a as old as 1974 island issue, then these diplomats also caution the government, saying that reopening it can open a Pandora's box. It can make it a problematic for countries' relation with even Sri Lanka. As you directly know that China is also trying to entice Sri Lanka for quite a long period of time, at least a decade, through its initiatives like Belt and Road Initiative and its port development processes in Hambantota and other projects. So India can get harms by this kind of issue when Sri Lanka also turn their side against India by getting hurt from these kind of talks. But even there are other people also who say that there is a necessary space that is provided under the international conventions by which you can raise your points. But because number one, Indian fishermen, those are detained, there should be some mechanism by which, some mechanism should be drawn by which the Indian fishermen's problems also are dealt with nicely. Number two, if Katchatheevu Island historical disputes are there, and if Katchatheevu Island has been already given to Sri Lanka, some sort of leasing can happen. These people suggest that some sort of leasing can happen from the Sri Lankan side. So that's why these disputes can be minimized. So this is the other thing that the people are talking about. So this was all about the Katchatheevu Island. What was the problem? Why there is the debate actually has its own pros and cons, and how it has been historically a disputed section. Thank you for listening to us. For more such videos, you can like the button and subscribe the channel. Thank you.